We'll proceed in the order in which the cases are scheduled on the docket. After the oral argument in our first case, we will take a 15-minute recess. We ask the attorneys to join us in the attorney's lounge for coffee. Our first case is Cessna Aircraft Company versus certain underwriters at Lloyd et al. Counsel, ready to proceed?
I am, Your Honor.
That's right.
Counsel, I believe our clerks have explained to you our clock system. We have allowed it 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I would like to reserve 3 minutes.
So noted, Madam Clerk. You may continue.
Thank you, Your Honor. My name is Mary Barrier. I've been admitted pro hoc vici in this case, and I thank the court. And I represent Cessna Aircraft Company, who is the appellant herein. This case arises out of a dispute between Cessna and 3 of its insurers. The allegations in the complaint below involve Cessna's claim that these insurers refused unjustly and wrongfully to settle a products liability case after that case had been tried to a jury and a verdict entered. The policies at issue are third-party liability policies. There were 27 concurrent insurers on these third-party policies.
Counsel, am I correct in understanding that when you get down to the bottom of this case, it really centers on that series of emails that were exchanged that defined what the parties' agreement was as to the voluntary payment or not?
Your Honor, I don't think so. I think the first issue in the case is whether Cessna should have been allowed to present its evidence on bad faith. The second issue in the case is the contract issue that you're referring to, and in that case, we are contending that on that contract claim, the instructions of the court were incorrect because they didn't instruct the jury on the duty of good faith, and they also failed to instruct the jury on the elements of estoppel. And the emails and the testimony of the witnesses that I believe Your Honor is referring to relate to that issue about whether or not Mr. Glazer, who represented the insurers in the underlying case and who also represented them in this insurance dispute, agreed with Cessna that if Cessna would pay their portion or part of their portion of the underlying settlement, that any dispute arising out of that payment and Cessna's right to recover it would be restricted to the issue of whether the $41 million settlement was in part for punitive damages, and but they would not contend that the settlement was voluntary and unauthorized.
I guess my question is this. One of the issues you raise as to the jury instructions or the verdict form related to your equitable estoppel defense, that wasn't properly explained to the jury. Am I right? That was one of your issues? That
was one of the issues. There was no instruction given, so the jury couldn't determine that their agreement, in fact, would have stopped them to later contend that our payment was unauthorized and voluntary.
Right. I guess that's what confused me, though. I didn't see or I didn't understand what they represented in that series of emails that is inconsistent with the position that they were taking at trial.
The position that the emails themselves indicate that they reserved rights, and the only trial testimony was the testimony of Ms. Kaiser and Mr. Wakefield, and that testimony was that there was an oral agreement, which is recognized in Florida and has been since 1956 in the Cahill case, that there was an oral agreement that if Cessna paid the disputed portion of their share, they wouldn't contend that the payment was voluntary and unauthorized, and that alone barred Cessna's right to recovery.
And this is your evidence of your affirmative defense of estoppel?
This is our evidence on the reliance, the representation by Mr. Glazer, the reliance by Cessna, the consideration we paid, and then the agreement, therefore, was that what should have been contended at trial was the $41 million settlement included a payment for punitive damages. That was an uncovered claim.
With regard to your first issue raised on appeal, whether the trial court erred in abating your claim for bad faith failure to settle. Why isn't the Florida Supreme Court's opinion in Government Employers Insurance Company versus Grounds dispositive of the choice of law issue?
The court's decision in the Grounds case in 1976 involved the duty to defend and the performance of the defense in Florida. Even if performance were the category of the item that we are supposed to be looking for, and Cessna contends it is not, and I'll get to that in a minute. But even if you looked at performance under the Grounds case, what we're talking about is the breach of the duty to negotiate the settlement. That settlement wasn't negotiated in Florida. The settlement was negotiated by a London insurer, a New York lawyer, Mr. Glazer, who represented those insurers, a New Jersey claims representative, the AAU claims representative, and the plaintiff's lawyer in Pennsylvania. And the issue of Grounds, the performance in Florida, that just wasn't an issue at all. Plus, since Grounds was decided, the Supreme Court of Florida has decided the State Farm versus Roach case in 2006. And in that case, the Supreme Court made clear that in interpreting the parties' rights and obligations under an insurance contract, that lex loci contractus applies. And they specifically reject the most significant relationship test, and they also reject, which includes as part of the test, one of the factors is where is the contract going to be performed. And they say that you should not apply that with insurance contracts because you should have stability and consistency in the interpretation of the parties.
Does the bad faith failure to settle claim require interpretation of the insurance policy itself?
The duty to settle is the contractual duty that's at issue. And yes, you do have to interpret the parties' rights and obligations under the duty to settle. And under Kansas law, which we also contend is applicable here because it was a Kansas contract, that duty includes the right to bring that bad faith claim with all the other contract claims. And it also, so both for the reason that the court should have applied the contract law of Kansas and for the reason that under contract law in Kansas, you bring the bad faith claim with your other breach of contract claims.
Is it your contention that there were no coverage issues to be determined in this case?
Yes, it is, sir. There were no coverage issues. And that is a red herring that the London insurers...
Well, didn't the appellant of the appellees dispute the coverage for the entire settlement based on the voluntary payment?
They didn't. They disputed the reasonableness of the payment, and they said that $31 million was reasonable. But the provision with respect to voluntariness isn't a question of coverage. It's a fact question with respect to the conduct of the parties. And Roach, the Supreme Court of Florida expressly says in Roach that the parties to the contract of insurance bargain for the place of execution jurisdiction to control their actions under the contract. So what they did in terms of settlement, or whether Cessna was making a voluntary payment or whether they had an oral agreement with the London insurers, those are conduct questions under the...
Let me ask you this question. I'm having trouble even understanding what the bad faith claim was.
Well, Your Honor, we didn't get to present our bad faith claim, so I understand the evidence on bad faith was not presented below.
I guess just in concept, this is not a case where the insurer said, we're not going to settle, and as a result, the insured, your client, was exposed to something more than they would have been had they made a reasonable settlement. In this case, your client, voluntarily or not, decided to pay more than what the insurer wanted to pay, which I guess may have increased your exposure for the deficiency, but that was based upon your actions rather than theirs, wasn't it?
I don't believe so. The refusal to accept the insurance settlement, which was negotiated not by Cessna but by their own insurance claims agent and was agreed to by 20 other participating insurers of Cessna, if that case hadn't been settled and had gone on, then Cessna's deductible would have continued to be expended in the defense costs.
But none of that happened. None of that happened. It didn't go on. You made a payment. That $41 million ended that case, ended the tort case. So there's no $480 million out there in the wings now.
That's very true. But the payment that we made was simply our deductible and that portion of their share that they wouldn't pay.
Right. So that's a contract case. I mean, I don't understand how this now becomes a bad faith case because you did settle the case. You have no more exposure except your contract exposure, do you?
You can bring an action for bad faith if the insurer's conduct is wrongful and you are damaged thereby. We were damaged to the tune of $3.5 million, which we paid based on our agreement with them, that we could argue about whether the settlement itself was reasonable later.
Right, which gets me back to my initial question, that isn't that the essence of the case? Isn't this really a contract case about the substance of those emails and what they reserve their rights on? I mean, isn't it subsumed? Aren't your damages the same under a contract case based upon those emails versus this reverse bad faith case?
Under applicable Kansas law, our damages are contract damages because bad faith damages caused by an insurer's wrongful conduct are contract damages under Kansas law.
Well, counsel, if there's no coverage, then there can be no bad faith claim, can there?
That's true, but there was, if there was no coverage, they wouldn't have had to pay anything at all, Your Honor. This is just like this.
In the underlying tort claim, the jury awarded punitive damages. Is that correct?
In the underlying products liability case, they did, $400 million.
Did the amount of settlement exceed the award for compensatory damages?
No. The award for compensatory damages was $80 million. The settlement was approximately half of that, $41 million. It's undisputed that those damages were covered, and that
the coverage for punitive damages was not an issue in this case.
It was not. And in fact, the trial court instructed the jury that the insurance company did not pay punitive damages and it was against the public policy.
But you'll be satisfied if we reverse on the basis of no instruction on estoppel, won't you? You're still going to make the same arguments to the jury that the insurers are stopped from claiming that they didn't authorize a settlement. And then a jury can determine that they're stopped, right? And the same amount of damages will be applied.
We would be happy, of course, if the court reversed on whatever grounds the court establishes are successful.
But you get to the same result.
I would also add, though, that we would appreciate when the court reverses, if they do, if they would instruct the trial court that we are allowed to present evidence on our bad faith claim and that the contracts should be construed under Kansas law.
But if the jury is instructed on the estoppel argument and the jury determines that the insurers are stopped, you won't ever get to the bad faith claim. You'll have your damages awarded in that action.
We will not get additional damages, but we should.
What additional damages would you be able to obtain with the new trial and with a bad faith claim?
We would not be able to. The damages would be identical, Your Honor.
That's what I thought. That's what I said.
Yes, you're correct. They would be identical.
You are into your rebuttal time.
I beg your pardon?
You are into your rebuttal time.
I am, sir. Does the court have any other questions? All right, then I will save the remaining minute and a half then. Thank you.
Thank you, counsel.
May it please the Court, Neil Glazer, D'Amato and Lynch, admitted pro hoc vice. With me is my colleague Dennis Lowry of Clark Partington in Pensacola. I think what all of you have been struggling with, trying to get your arms around what Cessna's bad faith claim was, is precisely what we have struggled with and what Judge Deeker struggled with.
Actually, would you mind, I'm sorry to redirect your focus, but would you mind discussing the estoppel claim?
Yes. That is not only a red herring, Your Honor, that is a giant red herring. Cessna was given the opportunity to have only its witnesses testify about what I call, quote, the deal, unquote. Mr. Wakefield, the general counsel, testified at length, both on direct and cross-examination. Barbara Casier, Textron's assistant general counsel. Textron was Cessna's parent. Also, extensive direct examination, cross-examination. There were 2 exhibits that you referred to, which, according to Ms. Casier, in the email says this is intended to memorialize our agreement. So the jury saw and heard a passel of evidence about what this deal was. And they also heard Cessna's counsel during closing arguments try to argue what the limitations were on the London insurer's reservation of rights, what we could argue about at some later suit.
Is this a harmless error argument?
Absolutely a harmless error, Your Honor. There was no question that the London insurers and Cessna reserved some rights to sue each other over something. The argument, I'm sorry.
If we assume that the appellants placed some evidence in the record on the estoppel issue, is it correct to assume that the appellants were also entitled to a jury instruction on estoppel?
I don't think that it would. First of all, Your Honor, remember, this was a long, pretty complicated trial with a lot of difficult concepts for a lay jury. They're hearing about London insurance coverage. They're looking at policies. They're hearing about an underlying suit. And I think Judge Geeker took a practical approach, and he explained it in his jury instruction in terms that a lay jury can understand. He asked,
Counsel, would a lay person understand the elements of estoppel?
Well, he used the term forfeiture, and he used waiver or forfeiture and explained, in essence, what Cessna's arguments were.
Yes, but my question to you is, would a juror understand the elements of estoppel?
If they were sitting in a room and that were put on a sheet of paper in front of them, perhaps in the context of a trial where they just heard a week of evidence.
But that's assuming they were put on a sheet of paper for them.
Yeah.
But my question is, would a lay person know, without putting the elements on a sheet of paper, know the elements of the defense?
I think they had a sense of what was involved. Could I speak for each juror? No. But they understood what Cessna's argument was, that we had made some type of promise to Cessna over what we would argue about later, and we tried to welch on that deal. And in fact, Barbara Casier of Textron claimed right in front of the jury that London insurers bushwhacked her, went back on the deal. The fact of the matter is the jury understood what Cessna's argument was.
Under what standard should this court evaluate the trial court's statement that a layperson would understand the concept of waiver?
Yes, because of the context in which it was presented to them. Remember, they had hours of testimony and counsel argument explaining to them what Cessna's arguments were, that we gave up our right to our exclusive right to settle and to insist on the voluntary payments clause because we made this deal and we limited ourselves as to what we were going to litigate about. They understood that. They just didn't buy Cessna's argument, and the reason they didn't buy it is because there were 2 documents we put up on the screen that said we can litigate about any issue we have. And in fact, I asked Ms. Casier, what about any didn't you understand? So I think the jury got it, even without a technical instruction on the elements of estoppel or on the elements of waiver.
I guess, and maybe I'm answering my own question by saying it took me several times of reading that email to understand what the deal was, but once you read it several times, it becomes very apparent, doesn't it, what the deal was. They can make, your clients were only willing to fund their share of up to $25 million of insurance money. You were willing to let them settle at a higher amount at their own risk. I mean, isn't that the essence of it?
That is the deal.
And you were reserving your rights to sue each other later about whether a portion of the excess they paid was for punitive damages, and they could sue you to claim that you didn't settle at the amount you should have settled at, wasn't it?
Well, among those reasons, but any meant any, whatever grounds we had for asserting that we do not owe money of ours that you have spent without our permission, those we could assert, and we did assert. I mean, we're not dealing with unsophisticated people here. I mean, we're dealing
So
with...
is it your position that the appellants did not place any evidence in the record on the defense of the estoppel?
I don't think they put in any persuasive evidence other than self-serving oral testimony of the two witnesses that was belied by Assistant General Counsel of Textron, Barbara Cassier's own email, and Counsel for London Insurers' response there, too. In fact, she said at the end of her email, silence is deemed acceptance, and therefore a response went out specifically saying we're not limited to a counterclaim. We can assert any claim in any form. I don't think anything could have been clearer to the jury. They paid attention to what was written by lawyers rather than what lawyers several years later said to protect themselves after the fact.
Let me, along that same line, were there any parole evidence objections, or was that issue discussed below? I know it's not here before us now, but if the deal, as we're calling these emails, is as clear as they now seem to me, at least, to have been, why were people testifying as to what they meant?
Well, you're right. There would have been parole evidence objections, but I chose to proceed by way of cross-examination instead of making an evidentiary objection on that basis. In retrospect, perhaps that objection should have been made, because clearly it was parole evidence intended to contradict the plain terms of the written agreement. It wasn't to vary or supplement, it was to contradict. Let me move on to the other issue that you and I have been struggling with, and I put it under the category, where have we sinned, such that Cessna has a bad faith claim against us? We did not refuse to defend them. In fact, we spent millions of dollars. When I say we, I mean London Insurers and the other insurers. Spent millions of dollars defending them across the board. Compensatory damages, punitive damages, got the best appellate lawyers we could find. We did not wrongfully deny coverage, nor do they allege that we did. There was no excess judgment, excess of the $500 million policy limits, even if the punitive damages award of $400 were covered, which were not. So there was...
Help us understand, then, what, if they've told us the damages they could recover would be the same under a bad faith claim and under a contract claim, what are we missing in trying to understand why they should get to try both of them together?
Well, I won't say you're missing anything, but I think the approach is somewhat different that I would take. This started off as a contract case. We, meaning London Insurers, commenced the case with a declaratory judgment action against Cessna, an affirmative claim citing the policy provisions that we have the exclusive right to settle, and that if you voluntarily settle, it's for your own account. That was our affirmative claim. Their counterclaim was that we somehow breached that contract. Okay, and we're not entitled to rely on those provisions. That was one counterclaim. Another counterclaim was bad faith failure to settle. As Judge Lewis pointed out, if there's no coverage, namely if by virtue of the terms of our insurance policy, we don't cover that voluntary payment, that extra payment that Cessna made, how can there be bad faith? And so the way I would approach it is, you are correct, the damages are no different, but since we started off with what I call a straight contract claim, so you don't get confused about whether bad faith is contract or tort, you start off with a straight contract claim. We had a contract that said A and B. We're standing by it. Cessna comes back and said, you breached the contract, you can't stand by A and B, and also you're guilty of bad faith failure to settle. So far as I know, under Florida law, under Kansas law, no insured has the right to go off on its own to settle with the insurer's money unless the insurer has refused to defend, has wrongfully denied coverage, or has exposed the insurer to an excess judgment. None of that happened here. So if we didn't breach any of our contractual obligations, how is Cessna excused from its contractual obligations to honor our right to have the exclusive right to settle or to refrain from voluntary settlements? Well, they didn't prove a breach, so they were not excused. You never even get to bad faith. The reason Florida case law states, and Judge Geeker, in the exercise of his discretion, abated the bad faith claim, is because when you inject psychodrama, like what was this claims person thinking? Did he have evil motives? Did he review every piece of paper he should have? When you inject that into a straight contract dispute case, you jaundice the jury's determination of the straight contract question.
I guess that's the answer to my question. It interjects issues that will convolute an otherwise straightforward case.
And that's exactly what the case law says. It taints the pure contract considerations.
Can you address one thing that counsel said? She spoke of a Roach case and its modification of the Supreme Court's ruling in the Grounds case. What's your view on that?
Well, first of all, this whole question of whether Florida law or Kansas law applies is a false conflict on the issue for which they've raised it. There is no Kansas law, and Cessna has presented none, which states, implies, or suggests that a trial court must try a straight breach of contract claim together with a bad faith claim, that a trial court judge has no discretion to defer the latter until resolution of the former. So there's no Kansas law to that effect, and there certainly is no Florida law to that effect. So we don't think the choice of law matters, and there really isn't a choice of law issue here. If there were, and we had to decide, well, I think you hit upon it when questioning Cessna's counsel. There was no dispute really about interpretation of the insurance policy. Cessna never said they didn't understand what exclusive right to settle means or voluntary payments mean. What they were attacking is how we performed our alleged duties under the contract, not what we did. That's performance. And when you're dealing with performance of an insurer, you look for the place of performance. Now, she can point to this individual in this state, that individual in that state, but the bottom line is you had a Florida case.
Counsel, getting back to the estoppel issue.
Yes, sir.
If a party presents some evidence on the defense of estoppel, some evidence, isn't the party entitled to an instruction, a jury instruction, on the elements of estoppel?
Well, first, Your Honor, I do not think, in reviewing the testimony, and especially in light of the documents, that Cessna put forth a prima facie case of estoppel and proved all of the elements. They never even used the word misrepresentation in their evidence. They never used the word reliance, and they never used the word estoppel. So, given that gap in the evidence that they put forward, I don't think an estoppel instruction not only would have been warranted, I think it would have been improper. But
the trial court just said in regards to the appellant's specific request for an instruction on estoppel, that a layperson knows the elements of estoppel. Is that correct?
Well, no, I don't think a layperson does know the elements of estoppel. I think what the judge was getting at, I don't think
What was the judge getting at?
Pardon?
What was the judge getting at?
What I think what the judge was getting at was the jury heard a lot of argument from Cessna's witnesses about what their grievance was, and they heard counsel's argument to the jury about what Cessna's grievance was and what kind of relief they wanted, and that by using the terms waiver or forfeiture of London insurers' right to insist on their exclusive right to settle, and giving the jury the reasons why that waiver or forfeiture might occur. We didn't have a reasonable basis for our settlement, or the reservation of rights was limited. He got there in sum and substance, even though he did not technically charge the essential elements of estoppel.
And in doing so, by instructing them that their burden on waiver or forfeiture is only greater weight of the evidence, that was a lesser burden than they would have had to show had he given them the instruction on estoppel, isn't it?
Well, I think that's correct, Your Honor. I think if, in retrospect, it might have been beneficial to us. We won on that issue anyway, but I think if the jury had to go through the checklist on the essential elements of estoppel, they might have reached a favorable conclusion on that issue faster than they did.
But by mentioning the words estoppel or waiver in a special interrogatory jury verdict form does not moot the need or the requirement to provide a specific instruction to the jury on the elements of estoppel, if some evidence of estoppel has been considered in the case, does it?
Can I have that question again? I'm sorry, I didn't get it.
If, in this case, it was a special interrogatory verdict form for the jury.
Correct.
And the words estoppel, I think, were used as part of that special interrogatory verdict form.
It was not.
Waiver was
Waiver
as well.
was.
And maybe just your own reliance, I'm not sure. But the question is, assuming that it was, that was still does not moot the need or the requirement that the trial judge specifically instruct the jury on the elements of the affirmative defense of estoppel if some evidence has been presented to that jury on that defense of estoppel. Does
As
it?
you stated, Your Honor, no, it does not generate that requirement. Do we have any further questions? Thank you. I'd like to finish early for a refreshing change of pace.
I'd like to just address a few points that came up.
Before you get to that point, counsel, you've also requested that we award attorney fees in this case. And you refer to the provisions of the insurance policy as the basis for awarding fees in this case. What specific provisions of the insurance policy provide for attorney fees in this action?
In this appeal?
Yes.
We filed the motion for attorney's fees to protect us because there is some indication in Florida law that if you don't request the attorney's fees on appeal, even if you subsequently prevail below.
But you relied on the provisions of the insurance policy as the basis for your request. My question is, what specific provisions in the insurance policy authorize the court to award attorney fees in this case to you, if you prevail?
They would be in the policy itself. It would be that portion of the policy that speaks to supplemental payments. If an insurance company forces a policyholder into litigation, the law is that that policy provision can be interpreted to provide that the policyholder is entitled to receive attorney's fees. But we do not contend that the court that we are entitled to the award at this time. We would only be entitled if we prevail below. May I make one quick point, Your Honor, that I wanted to make about the estoppel?
Counsel, your time has expired.
I realize that, sir. Could I make just one quick point about estoppel? I realize you would have to extend my time.
We'll allow you to make that one quick point.
Thank you. I merely wanted to point out that on the estoppel argument, you merely have to show substantial evidence. We do not have to prove a prima facie case. And if we show substantial evidence, we're entitled to the instruction. Thank you, sir.
Thank you, counsel. The court stands in recess.